In this episode, we will be discussing the recent California COVID-19 tenant law. This video is brought to you by AmerUSA, where you can screen tenants 24 hours a day. The California State Legislature passed legislation amending California's Code of Civil Procedure, which impacts the rental housing industry. This legislation appears to be effective upon its signing, which occurred on January 29, 2021. So what type of impact will this have if you're a California landlord? Well, it can have a big one. This bill affects the rental screening of prospective tenants. It would prohibit you or a tenant screening company that evaluates the tenants from using an alleged COVID-19 rental debt as a negative factor for the purpose of evaluating a prospective housing application or as the basis for refusing to rent a dwelling unit to an otherwise qualified prospective tenant. So what is a COVID-19 rental debt as it's been defined? Well, it defines it as an unpaid rent or other unpaid financial obligation of a tenant that came due during the covered period, which is between March 1st, 2020 and June 30th, 2021. So it is very important to remember, if you encounter any negative rental debt that occurred during that coronavirus time period, you need to be very careful as to whether or not you act on it. If you use a tenant screening service such as AmerUSA, that data should automatically be suppressed. But if you're the type of landlord that does their own research with regard to civil records and discover an eviction or a judgment that occurred during that time frame, be very careful and make sure you have thoroughly reviewed the entire legislation so you understand what you may and may not do. The coronavirus pandemic was bad enough, and the last thing any landlord wants is for a tenant to infect their rental property business with a lawsuit that's difficult to defend against. If you would like to see more videos about being an American landlord, please like and subscribe.